Well, top of the morning to you all. Beautiful day out there, thank God. I had reached out to Bob to see if he would come on this call, and Brian, thank you so much too for joining him. With the reopening of our businesses coming soon, hopefully, we just wanted to make sure that all the employers have their ducks in a row, so to speak. So today's session will give you the opportunity to speak to two actually chamber member attorneys, and they specialize in employment law. So I'll very quickly introduce our presenters this morning, and the first one is Bob Kilroy. Bob, I looked up, you have quite an amazing bio. I won't mention all your accomplishments, we'd be here all morning, but Bob is a partner and chair of the Labour, Employment and Employee Benefits Group at Myrick O'Connell, where he specialises in employment litigation in defence of corporations and their executives. He has extensive experience representing hospitals and physician groups. He routinely appears in federal and state courts throughout New England and beyond, as well as before the Massachusetts Commission Against Discrimination and the Equal Employment Opportunity Commission in defense of claims of discrimination, sexual harassment, wrongful termination, breach of contract, whistleblower, and wage payment violations. You're a busy man, Bob. This was my favorite part. Prior to joining Myrick O'Connell, Bob served 10 years active duty as an officer in the US Marine Corps. So kudos to you, my friend, and thank you for your service. And he awarded 4 medals for leadership excellence there. So thank you, Bob. Bob has annually been named a Massachusetts super lawyer by Boston Magazine and Law and Politics every year since 2011. He was also previously named a Massachusetts Rising Star for 3 consecutive years. And how I know Bob is he's a former chair of the board of directors of the MAC, and he's a sitting chairman of the board of trustees at the Milford Regional Medical Center. And that was a short bio, folks.
Thanks, Laura.
So Brian Casaselli, I hope I said that correctly. He's the associate in the Labour and Employment Practice Group at Myrick O'Connell. And Brian focuses his practice on representing employers, federal and state courts in Massachusetts, as well as before the Massachusetts Commission Against Discrimination and the Equal Employment Opportunity Commission, defense of claims of discrimination, sexual harassment, wrongful termination, breach of contract, and wage payment violations. Brian also represents employers in wage and hour investigations by the US Department of Labor and the Massachusetts Attorney General, and in unfair labor practices proceedings before the National Labor Relations Board. And he also counsels employers on day-to-day employee issues and has experience drafting employer handbooks and other employer policies. So you guys are quite busy, I'm sure. And thank you for joining us this morning. So, all right, so how about we get started? Bob and Brian, you have the virtual floor, as they say.
Sure, and let me just make sure that everyone can hear me okay. I'm going to share my screen in a second. I'm on my firm's Wi-Fi, and it said it might be a little slow, so I hope everyone can hear me okay.
Hear you fine.
Okay, great. So I'm going to share that right now, and then we'll get it up and running, and I'll let Bob take it away.
Excellent. Well, thank you, Laura. Appreciate the intro. You should have led with the chairman of the board of the MAC, though. That's the more important in this instance. And thanks for everyone who are joining us today. Hope everyone's staying well and safe. What Brian and I have planned is probably about a dozen or so questions, question and answer format, that we'll walk through. These are some of the leading questions we're receiving from our clients currently. And by all means, feel free to interrupt us with questions, or if you prefer to wait till the end, that's fine as well. We're open to either approach, and we'll step through this. So let's begin with, Brian, if you want to advance the next slide.
Yeah,
first
absolutely.
set of questions. So workplace safety. And I'll ask this of Brian. What steps should employers be taking as they think about reopening to ensure that the workplace is safe for their employees? And really, when I'm asking this question, I'm asking it from the perspective of a litigator who's expecting there are going to be claims by disgruntled employees if things don't go well or if they feel the workplace isn't safe. So what should folks be thinking about?
Sure. Well, thanks, Bob, and thanks, Laura, and everyone for attending this morning. It's great to be here, and I like all Bob's statement that I hope everyone is doing well and is safe and healthy. Obviously, at the forefront of any considerations for returning to work is employee safety, and I think at the outset we would certainly encourage employers to review guidance that has been published by the Centers for Disease Control, the Occupational Safety and Health Administration, as well as some preliminary guidance that was recently released by Governor Baker's Reopening Advisory Board. We expect additional guidance from that forthcoming, but I think those are three initial steps that employers should take. I think in addition, there should also be an enforcement of safety mechanisms, meaning that you should be wearing face masks covering employees in the workplace. You should implement policies that are aimed at maximizing social distancing in the workplace. You need to ensure that there's frequent cleaning and sanitizing of high-touch areas. And then, if your company has a common area where employees tend to congregate, you should eliminate gatherings in those common areas that would violate the social distancing guidelines. Certainly encourage employees to frequently wash their hands and use hand sanitizer. And then also, I think, and we'll touch on this in a bit, but definitely require self-reporting by employees where the employee may begin to feel symptoms of COVID-19 at work, because you'll want to develop a plan for isolating the employee and sending the employee home.
Now, I'll echo some of what Brian said, but I can envision any number of employers, once you're back to work for a week, 2 weeks, what have you, that business is going to return as normal in a sense, and people are going to become lax, and you're going to have folks who start kind of poo-pooing these ideas of wearing the face masks, of having to worry about using the hand sanitizer, of not wiping down the coffee area, the coffee pot, not cleaning the door handles as much as they had. You become complacent. That's human nature, but I want to caution you, be careful with that. And it's really up to the folks on the line today, key managers and so on, to set the example, to enforce this, because what will invariably happen is there'll be a relapse. Someone will actually end up getting COVID-19. They're going to attribute it to the workplace, particularly if it spreads through the workplace, like you've seen in a Walmart or what have you. And then you're facing a lawsuit. So it's important not to get lax and to document what you're doing in terms of enforcement mechanisms for wearing a face mask, for ensuring social distancing. I talked to a client yesterday who has an on-site cafeteria. They're starting to bring their folks back next week. The cafeteria chairs are all gone. They're not allowing people to congregate in the cafeteria. If you have break rooms, that's something you might consider, is putting the break rooms off limits, or you can only go in, get your coffee, go out, those type of things. So just things to keep in mind. Brian, I just touched on face mask. What about the employee who, is kind of an old codger and says, yeah, I'm not doing that. I'm fine. I'm not wearing a face mask.
Yeah, and this is undoubtedly going to happen, at least in some workplaces. I think the initial step is, to pull the employee aside and say, hey, look, I understand your position, but these are the guidelines that are out. This is what Governor Baker has mandated that we do. You're not being targeted here. All employees are required to. If the employee still persists and refuses to refuses to wear a face mask, then I think you have to go through the normal disciplinary procedures that you do and discipline the employee. In addition, given that his or her presence in the workplace would be in violation of the Governor Baker's recommendations, I think you have to send the employee home and put him or her on essentially an unpaid administrative suspension for refusing to adhere to the requirement to wear a mask in the workplace. I don't know if there's anything you wanted to add on that, Bob.
Oh, good.
Sure. So moving to the next slide, obviously There's a lot of questions about what employers can do and should do with respect to testing for COVID-19 to determine if employees have it before returning to the workplace. So starting off, Bob, can I require employees to have their temperature checked? And I guess if the answer is yes, how do I do that?
Sure. So it is yes. And I want to caution folks, it's yes because of the pandemic only. So normally the answer is no. The EEOC, Equal Employment Opportunity Commission, would say, no, you absolutely can't. It's a medical test. You can't be doing that to your employees. But because we're in a pandemic environment, they've lessened those restrictions and they're allowing employers to conduct temperature checks. So how do you do it? A couple ways you could consider doing it. One is you could just put out the word to your employee base that they are required to take their own temperature before they come to work. If they have an elevated temperature, they don't come to work. Or you could have someone designated, and I wouldn't, I'd have someone like in HR designated who's at the front door and is going to take temperatures of employees on the way in. I'd make sure I have one of those no-touch thermometers if I'm going to do this, right? You don't want to be repeatedly using an oral thermometer, obviously. And you have to decide, are you going to log the temperatures or not? You wouldn't have to. But if you do, those are confidential records. You need to make sure they're segregated from any other file, kept locked up, no one has access to them. If you take a temperature, and typically the guidelines coming out of the CDC is 100.4 degrees and above is problematic for COVID-19. So you have someone test in that range. You would want to take them aside. You wouldn't want to publicly announce it. You take them aside to an isolation room, let them know, hey, you've tested, your temperature's above this level. We need to send you home. And you're going to then have to self-quarantine. And we can talk about that a little later in the slide deck as to how long and so on. Now, one problem that you would have, let's assume you're a Waters Corporation, you're a large corporation, you've got hundreds of employees coming on site. If you're doing these temperature checks, there may be an appreciable wait time, right? You're standing in the parking lot, 6-foot distances, social distancing, you're waiting to get your temperature taken, and you're out there for 15, 20 minutes. What does that mean? Well, that means you probably have to pay them for that wait time. So if you're going to impose this, you want to make sure that you're covering their wages during the time that they're required to wait.
Bob, what about if an employee, refuses to have his or her temperature taken? If they're saying, nope, you're not going to do that, that's a violation of my privacy.
Sure. And certainly employees have privacy rights not to have you take their temperatures. Under the law, the privacy right will be weighed against the right of the employer having a legitimate business reason for invading your privacy, if you will. Here, the employer's right's going to trump the employee's right. And so you would be able to say, okay, I understand, and now we're going to send you home because we can't confirm whether or not you have an elevated temperature. We're going to send you home, and it's up to you, the employer, whether it's paid or unpaid. I would be recommending, obviously, that it be unpaid. I don't think you need to pay someone who's not working for you and is refusing a valid directive. And so I would send them home and would not allow them to return until they're willing to undergo whatever other employees undergoing in terms of temperature checks.
And I think you touched on the elevated temperature piece and the isolation. So just moving to, so with respect to COVID-19, can I require employees be tested for that too, or in addition to
same analysis? Yep, same analysis as with temperatures. Normally the answer is no, but because we're in a pandemic environment, the EEOC is saying yes, you can. Now the difficulty here is the availability of testing and the availability to get into a physician's office who will do the testing for you. So I say that you can do it, you can require it, just be mindful there's a practical application here that may not work well if it turns out that the employee just can't physically get to a testing site or needs a doctor's note to be able to get to the site to begin with, and they can't get that note from their doctor. But in general, the answer is yes, you could. And I'll just, in the interest of time, jump to the third bullet there. Can you require antibody testing? I had a client call me on this last week because there's a lot of hope, right, that antibody testing is going to allow us to say we're all immunized, we've already been exposed, and so now we're good, we can go in, we don't need a face mask, we don't need anything. The answer here is clearly at the moment, now it could change, but at the moment, the answer is no. No, you, the employer, cannot require antibody testing, and the reason you can't is the FDA has made clear in its guidances that antibody testing is not reliable and accurate enough to predict immunity in full, nor to assess by way of diagnosis whether you actually have had COVID-19. So don't go down the path of antibody testing for your employers. Want to jump to the next slide, Brian?
Yep.
So Brian, employees refusing to come to work, and I'm going to give you a variety of scenarios just to kind of summarize the slide in a sense. So there's the employee who's just afraid, right? Says, you know, look, I'm a little freaked out. I've seen what's happened in Walmart. I've seen what happened in the Biogen conference. You know, this stuff runs rampant. I'm afraid to come to work. Then you have the employee who's not so much just afraid, but who is actually panicked and is telling you, look, I have an anxiety disorder. You know, I've been to my physician. I have full-blown anxiety, panic, and my physician can confirm it. Then you've got the employee who's saying, I'm over 65, or I've got asthma, or I've got lung disease, COPD, and my physician is advising me to self-quarantine. I don't think I should come to work. And then lastly, and we can go back over these one by one, but lastly, you've got the employee who says, look, I live with my elderly mom or dad, and you know, they're very vulnerable. They're 72. And I'm afraid if I go to work, I'm going to bring home the virus unknowingly to them. And let's face it, that can be a death sentence, depending on their underlying condition and so on, and how the disease might progress. So employees telling you they don't want to return to work because, first off, they don't think it's a safe environment. How do you respond?
Right, and certainly a lot to unpack in that slide, and I welcome Bob to jump into if there's anything that he wants to add. But I think initially, if it's an employee simply refusing because they're afraid and that there's no underlying health condition that the employee has, so for example, they don't have that anxiety condition that Bob mentioned, they don't have an underlying disability, mental or physical disability that might be exacerbated or influenced negatively by contracting COVID-19. And the employee has taken, has taken legitimate safety precautions. You know, they've implemented the social distancing requirements. They've required employees to wear masks. They prohibited congregating in common areas. Essentially, you know, following the recommendations of the CDC, OSHA, and the Governor's Advisory Committee. Then the employee's refusal to come to work simply because of fear is not a legitimate grounds. And you would be entitled as an employer to instruct the employee to come to work. Now, I think as a practical consideration at this point, though, you don't want to be the poster child for an employee going to a news outlet and saying, my employer is not listening to me. I'm nervous about going in the workplace because of COVID-19, and therefore, you know, I don't think I should, but they're still making me. Obviously, that would generate a lot of press and negative PR. So in that situation, I think it's our practical advice just to work with the employee, see if him or her would still be able to telecommute and perform the essential functions of the job at home if that's possible. If it's truly an operational necessity for the individual to be in the office, we would suggest contacting legal counsel to run through that scenario before you give, you know, an ultimate instruction. I think it's good to have a second set of eyes look through the steps that you've taken and steps that you may consider taking to address that individual. With respect to the individual who has a anxiety disorder, so that would be considered a mental disability under the Americans with Disabilities Act. And in that situation, you're best advised to engage in an interactive dialogue with the individual. And that's going to be a conversation to essentially discuss alternatives to returning to the office. The most practical and common scenario we envision is simply allowing the individual to continue to telework while during the extent of this COVID-19 pandemic. Alternatively, you could consider providing an unpaid leave of absence to the individual as an accommodation as well. Is there anything further on that point, Bob, that you have before I move on to the next, or any of the two that I've discussed thus far?
On the first one, I would just say if the employee is saying, you know, I'm refusing to come, and let's face it, there are going to be some employees who refuse because they're getting such a good deal under the federal law and state law benefits now, where you get the additional $600 per week in unemployment benefits, right? So they may feel they're making out pretty well by staying out of the workplace, and might even be enjoying staying out of the workplace in that regard. If that's the case, just recognize that you are able to notify the DUA that they received a return to work notice, and you need to put the notice in writing that they're being ordered back to work at the same pay, same hours as before, same job. And you give them a by date by which they're supposed to return. And then assuming they reject it or they don't respond, then you provide in writing that they refuse to return to work. The DUA, it's up to them, but they should shut off benefits at that point. So it's just something to keep in mind in terms of, you know, one of the tools in your toolkit when it comes time to deal with someone who's just, for their own purposes, opting to stay out of work.
Right, that's an excellent point. And just to getting to the third scenario, so the individual has a condition that makes him or her particularly susceptible to contracting and maybe not dealing with COVID-19 very well. And that individual would very likely be considered someone with a disability under the ADA. And again, similar to the anxiety scenario, you should and would need to engage in an interactive dialogue with that employee, how best to reasonably accommodate his or her disability. And again, the two most common, allowing the individual to continue to telework or providing an unpaid leave of absence. And those two aren't certainly the only exclusive accommodations. You can explore others that would allow the individual to perform the essential functions of his or her job. But those are the two that typically come to mind at this time. And then the last piece that Bob mentioned is, well, what if you have a family member at home, and that family member may have a disability, or may just be elderly. 72, I think, was the age that Bob referenced, and there's no requirement to accommodate the individual simply because of the fact that there's someone whom is part of an elderly population or who has a disability at home. However, we would caution you greatly against moving forward with any kind of discipline or termination of employment on that basis. I think the reason for that is that you could expose yourself potentially to a claim of associational disability discrimination, where you're making this adverse employment decision against the individual because of his or her relationship with a family member who's at home with a disability. So again, practical advice: work with your employees. Don't be the test case for any kind of litigation there. Anything you wanted to add, Bob, on that?
Yeah, just the last thing I would say is, because managers often think lawyers are a nightmare because all they do is tell us what we can't do. The reality is, each of the scenarios we just went through, we could be more aggressive, and we could actually either require them to return or deem that they've abandoned employment by not returning, and we can set that up appropriately to mitigate the risk. So if you have managers or a CEO who's pushing you on that, by all means, get a hold of your employment counsel. It doesn't have to be Brian and me. If you have other employment counsel, talk through the scenario with them. But we can be more aggressive and let you know what the risk is, and we can mitigate that risk in a fair measure.
Sure. So moving to the next slide, and we know we touched on this briefly in one of the introductory slides. What should an employer do, Bob, if they find out that an employee who was in the office tests positive for COVID-19?
Sure. So first off, get them out as soon as possible, right? Isolate them, get them out of the office, send them home to quarantine. You want to ask permission from that employee to be able to disclose his or her name to coworkers. Now, the two scenarios, right? One employee says, no, I don't want anyone to know I have it. Then you absolutely cannot disclose the name of the employee to the coworkers. Now, that makes it more problematic for other coworkers to be mindful of, did I come in contact, if it was Brian, who's the one who had COVID-19, I'd like to know it was Brian because I know whether or not in the last week or two I came in contact with Brian. But if Brian says no to our HR director, I'm not going to allow you to disclose my name, then the employer is just going to want to say to those within the vicinity of the office Brian worked in, we had someone who tested positive for COVID-19, and you should be mindful of that. You should be aware of symptoms, cough, shortness of breath, fever, loss of taste or smell, those type of things. And so that they can take appropriate precautionary measures themselves, or they might want to go get tested themselves. But if the individual says no as to disclosure of the name, don't disclose it because they have an absolute confidentiality right in that instance. For the employee who's now out because they tested positive, you don't want to allow them to return to work until they've had 2 negative tests in a row. So this is where you absolutely want to require them to go get testing by their healthcare provider, 2 tests in a row, each 24 hours apart from the other. Assuming they're both negative, you could bring them back, assuming that there's been no symptoms without the use of fever-reducing medication. But what if the employee hadn't tested positive, but they started being symptomatic, right? Shortness of breath, they have a fever, they call their healthcare provider, the healthcare provider says, based on your symptoms, I'm confident you have COVID-19, no need to come in and be tested. As long as it doesn't get worse, here's, rest, lots of fluid, blah, 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 stay home, come into the ER if, things get worse. In that instance, you wouldn't allow them back into work until they have been 72 hours, and this is through the CDC guidance, 72 hours without fever or symptoms, such as shortness of breath, coughing, when they're not using fever-reducing medication, right? So 72 hours and 10 days since the symptoms first appeared. Now, if you go back over the last few weeks, you're going to see different guidances on this. Some say 7 days after symptoms first appeared, some say 10 days. The most current guidance is 10 days. In fact, we've had to update our policies on this point. So 72 hours without fever-reducing medication, no symptoms, and at least 10 days since symptoms first appeared, you could then allow them back into the work site. You could say, we're still not letting you in unless we have a confirmed test from a healthcare provider, if you wanted to go that route, or you could let them in based on the 72 plus 10-day issue. Next slide.
Sure.
All right, Brian, this is you. Governor Baker's going to start reopening non-essential businesses. We'll be lifting the stay-at-home advisory. So what happens to the Families First Coronavirus Response Act, where we've heard, about a month ago now about all this emergency paid sick leave, emergency family medical leave? Do the employees still have access to those provisions?
They do, and when the laws were passed as part of the Families First Coronavirus Response Act, they did set a sunset provision in them, and that sunset provision is through December 31st, 2020. So, to the extent that an employee does return to on-site operations and contracts COVID-19 or is advised by a healthcare provider to quarantine as a result, of potential exposure, he or she would be entitled to use their benefits under the Emergency Paid Sick Leave Act, and assuming they haven't used them up. And just as a brief refresher, that law provides employees, full-time employees, with up to 80 hours during or to use for a specific purpose enumerated by that law. There's 6. If the employee's been diagnosed with COVID-19, if the employee is experiencing symptoms and is seeking a healthcare diagnosis, if the employee is caring for someone who has been diagnosed with COVID-19 or has been advised to quarantine by a healthcare provider. There's a few others, but I'll leave that at that for the time being. Part-time employees are entitled to the average number of hours that they work over a 2-week period. For those same reasons. And the Emergency Family and Medical Leave Expansion Act provides employees with up to 12 weeks to use leave to care for a child, a son or daughter, whose school or place of care has been closed as a result of the COVID-19 epidemic. There's obviously more specifics to those 2 laws, but you are entitled as an employee to continue to use the benefits after Governor Baker lifts the order, assuming that they are still available to you and you have not already exhausted them.
I would just say if your workplace isn't on top of those 2 new laws, you want to make sure that you get the advice and counsel you need to be able to implement them effectively. This is going to be a burgeoning area for plaintiffs' lawsuits, I guarantee it, because a lot of businesses will not get this right, will not be providing appropriate amounts of paid sick leave or paid family medical leave because it's very unusual. And so you don't want to become victim to one of these lawsuits. And it's easy enough to get the advice you need, to get policies put in place, to get forms put in place that will allow you to administer this correctly. Next slide, Brian.
Sure. So this one's you, Bob. Furloughed employees. So I know at the outset of when the pandemic really got going in March, that a number of employers started to furlough employees as opposed to lay them off, and there was some questions about that. So if you have furloughed employees during this 2-month period, are you as an employer required to call them back when Governor Baker reopens non-essential businesses and lifts the stay-at-home advisory?
Yeah, this is an easy one. The answer is no. So if you furloughed employees, you likely did it for operational business reasons to save money. You may still be in a posture where you're needing to save money. Business hasn't returned in full, so you can keep people furloughed. Sometimes people who are furloughed will turn into layoffs, meaning permanent layoffs, permanent terminations of employment. Sometimes you'll be able to get them back in a month, 2 months, 3, 4 months, what have you. Completely an operational business decision. It's not a legal decision by any means. And so don't feel required to bring people back who've been furloughed. If you are starting to bring them back, however, what you need to keep in mind. 1, you bring them back in a non-discriminatory manner. If it turns out, by way of example, that you start bringing back everyone who's in their 20s and 30s and all the 40-year-olds and 50-year-olds and 60-year-olds you don't bring back, you've got a potential age claim on your hands. Now, you may beat that age claim, but be aware of the optics of that. If you're bringing back all the white males and you're not bringing back the females, or you're not bringing back the Hispanics, that could be a ripe for a lawsuit based on discriminatory factors. And then beyond that, it's really what we've already talked about in the slide deck. Implement your safety protocols. One thing to keep in mind, if you're bringing back an exempt employee, so exempt meaning exempt from the overtime obligations under the Fair Labor Standards Act. Typically, you're paying them on a salary basis, a fairly significant rate of pay. Keep in mind that if an exempt employee works any amount of time during a work week, they're paid their full salary. So if you brought them back and you thought I'm going to bring them back in kind of part-time capacity, you'd want to talk to your employment counsel to be able to do that correctly, meaning change their job from full-time to part-time, and you may even have to change them from exempt to non-exempt. Those are things you have to work through. But if you're just bringing them back in general, you need to pay them their full salary. And obviously have a plan in place for those employees who might say, I'm afraid to return to work. Next up, telework. So Brian, we've got a whole host of employees that have been working effectively remotely, in part because we're trying to keep the business operational. It wouldn't be our normal process. You know, we'd rather have them on site, but we now have the ability to bring people back into the workplace with face masks and all the rest of it. Do I have to allow those who are teleworking to continue to telework if they express a preference to do so?
No, you don't. With the caveat that if you have an employee, and we touched on this briefly, who does have an underlying disability, a mental health, mental or physical disability, who may be at greater risk for contracting COVID-19, or the person might have an anxiety disorder that's really burgeoning as a result of having to come back to the workplace. I think that you need to engage in the process, the interactive dialogue process there, and very likely still permit those individuals to telework. However, if we're talking about a run-of-the-mill employee and the individual doesn't have any of those conditions, and your company has taken adequate safety precautions in anticipation of employees' return to the workplace, there is no requirement that you let employees continue to telework after the governor lifts his advisory.
If you have folks who you are going to require to come back on site, you have to give them like a 2-week notice, a 1 week, a month. What do you have to provide?
Yeah, there's no affirmative legal requirement as to how much notice you can provide. I think practically speaking, you want to give your employees a sufficient amount of time to get their affairs in order and/or their arrange for their schedules. They might have kids at home and they need to coordinate with the spouse as to who will arrange for the child care. So it depends upon each individual business, but I think a week, 10 days is probably a good recommendation for providing notice to employees. But again, there's no strict legal requirement that any kind of notice be provided.
Sure. And if you have employees who are ready to come back, you don't have to give any notice. Just say tomorrow, come on back in.
Right. Absolutely.
Right. Last question scenario.
Sure. So let's say the employees tested positive. They've been out of the office for the requisite time frame, as mentioned by the CDC guidance. But you want to require the employee to provide a doctor's note clearing them to return. Can you do that?
Yes, you can. Keeping in mind the concern that we noted about availability of testing. But that said, yes, you can require it. There's certainly that medical test that you're requiring is job related, consistent with business necessity under the Americans with Disabilities Act, because if they bring COVID-19 into the office or into your work site, there's a direct threat to others. So by all means, you could require the test. And Laura, with that, we've hit the key questions we wanted to touch on, but there's probably any host of other questions people might have, and we're willing to give it a shot and try and answer them.
Yep, let's open it up and see if anybody has any questions. I know I have a couple myself, but we let everybody else get first dibs on you.
Okay.
We'll let Brian
Hey,
Brian can take off his so I can see everybody. Awesome, thank you. All right, Toby, how are you?
I'm good, Laura. How are you?
Good, girl.
This is great. Thank you so much for hosting this. I do have a couple of questions, if you don't mind me asking. If I have so I am the owner of Goldfish Swim School. We're a small business in Milford, Mass. We teach kids how to swim ages 4 months to 12 years of age. My employee base is mostly part-time high school, college age kids, and then I do have a few full-time salaried employees as well as full-time equivalent employees. we are in the process of revising and updating our employee handbook with all of these new policies and procedures that have come out, and we are going to ask our employees to re-sign our handbook. Does that limit my liability in any way?
The simple act of re-signing the handbook won't necessarily limit your liability. What it will do is provide you an ability to show from a defense standpoint, if you ever got a claim, that they were put on notice to certain policies and procedures. So if they violate them, you're in a better position to claim they were informed, they violated, and therefore you have a legitimate business reason to impose discipline, up to and including termination of employment. But the act of signing the handbook standing on its own doesn't necessarily insulate you from a lawsuit. There are certain policies that we recommend that you actually get signed every year. So for instance, your sex harassment policy, your equal employment opportunity, anti-harassment policy, those type policies you want signed each year, because that does aid in your defense if someone brings a sex harassment claim, particularly if they haven't complained to you verbally beforehand or in writing beforehand. They just surprise you with it through the MCAD.
Okay,
Anything
great.
to add to that, Brian?
No, I actually couldn't hear. My Wi-Fi was cutting out, so I apologize for that. But Bob, please feel free to take these if I can't.
Okay.
Okay, and then I did have one more question. You mentioned when you were talking about the CARES Act and the paid family medical leave and sick leave, you mentioned just full-time employees. I thought this was applicable to part-time employees as well. And then is it still limited in the sense of if I have under 50 employees, then I don't have to provide this coverage?
So it is applicable to part-time employees as well. I apologize if I didn't make that clear. I think the under 50 threshold is, with respect to the employee who is at home as a result of the child care, needing to provide care for his or her child because their school or place of care is closed. There is no similar exemption for providing sick leave to the individual. So if you're a business with 45 employees, you are still required to provide paid sick leave under the Families First Coronavirus Response Act. What you would not need to provide, assuming you can demonstrate that doing so would interfere with the continuing viability of the business, is the right for the employee to take leave to care for, as I mentioned, a son or daughter as a result of the place of care or school being closed. Does that respond to your inquiry?
Yes, thank you so much.
And just to follow on that, the small business exemption for the under 50 employees that Brian just talked about, I don't view as a great exemption unless you really have the ability to show that your financial viability as a business is going to be so adversely impacted you might go under if you were to provide that benefit, keeping in mind that you get a tax credit for any of those benefits that you provide. So although the exemption exists, I'd be a little careful about using it. And, typically we get this question, a slight variant of this question is there a threshold 50 employee limit like the Fmla in order for these acts to apply to us? The answer to that is no. If you have one employee, these new acts apply. There is, for the expanded Emergency Family Medical Leave Act, a 30-day requirement. The employee has to have worked for you for 30 days to be eligible, but that's the only real requirement.
So that 30-day, does that furlough period come into play at all? So my employees have been furloughed since I shut down. Now let's say they come back. Does that clock start again for 30 days, or they've just been with me? And
let me ask you, I'm going to dodge the question slightly as I try and think about it. Had they worked for you 30 days prior to the furlough?
yes.
Yeah, then they're covered.
Okay.
What I don't know off the top of my head, and Brian may know, is if there was, let's assume they only worked for you 10 days prior, then they went on furlough. I don't know off the top of my head if the furlough time counts. I think it does, but Brian, you might know.
What I recall from the regs is that you had to have been on the employer's payroll for a period of 30 days. I don't know if that's active payroll or inactive. So it's a very good question, and I actually want to take a look at that now because I think it's worthy of a bit of additional research.
If anyone's in that position, feel free to shoot an email to Laura, and she can get a hold of us, and we'll research it and get an answer out.
Absolutely.
Thank you. This is going to kill us going forward from a small business perspective if we have to provide these benefits and you know, paid leave. Just an editorial comment there. I'm done.
Is there any other questions?
If Toby just asked another question,
from
we can
Milford
get it.
Regional.
Oh, somebody's on from Milford Regional.
Hi, it's Paige Whittingham from Milford Regional Medical Center.
Hi, Paige.
Thank you, everybody. This has been great. It's nice to meet you all. One question, we have had a lot of people, you know, since this began, that were in that situation with the concerns about coming into the hospital due to underlying health conditions and, you know, things that might fall under the ADA. And we have really kind of probably erred on the side of extreme caution and accommodated those pretty heavily. But as this is sort of evolving and things are getting a little bit more under control, and we're going to start resuming some of our other types of surgeries and things like that, we're definitely getting the sense the people that we have been able to put out on unpaid leaves of absence, that in their minds this may go on forever. And at what point, if these are not FMLA eligible people, but we've accommodated them, you know, for a period of time, at what point is it become unreasonable to allow them to be out on an unpaid leave of absence in those situations?
So there's not a black and white answer to that under the law. It's very fact specific, based on the underlying condition of the individual, the particular requested accommodation, what you've received for medical documentation from their healthcare provider. But in the instance where they don't have a doctor's note saying that they have to be out as a reasonable accommodation due to a healthcare issue, then you really would not have an obligation to accommodate. So you wouldn't necessarily have to continue the unpaid or the even paid leave of absence accommodation that you might have already started. This isn't one of those no good deed goes unpunished type scenarios where because you did it previously out of the goodness of your heart, you have to continue to do it. But what I would say is because it's so fact specific and so nuanced, you really want to talk to your employment counsel on any specific case so you can mitigate the risk appropriately. And I'm not trying to drum up business here. It's just, this is one that, you know, we deal with daily.
Yeah, it's sticky for sure.
Do we have any other questions?
So I have a question actually about accommodations for disabilities. I was recently at a post office, and it wasn't Milford, and it doesn't matter which one, but the woman behind the counter was not wearing a mask. The shield was maybe a foot wide, so there was plenty of opportunity for interaction. And I asked about that, and because the manager was there, and the manager said, oh, well, she has asthma, she doesn't need to wear a mask. So I guess my question is, you know, what accommodations do employers need to make? I mean, this woman is dealing with the public all day long. I'm just curious, because I personally, as a customer, was a little taken aback.
Sure. So the employer doesn't necessarily have a legal obligation outside of something that might be promulgated by the governor that's mandated as opposed to a guidance. So the employer wouldn't have an obligation to require wearing of masks in order to protect the public. I think most employers do require it just based on exactly the concern you just raised. The people will start voting with their feet and will decide not to frequent that particular establishment. When you see everyone else wearing masks in, you know, a particular place, whether it be a Stop and Shop or a, you know, Market Basket or what have you, where the employees aren't taking precautions, you're going to look for another place to shop. So, but strictly speaking, the employer's obligation isn't to that particular individual, except, and now we're getting kind of deep into the weeds here, but I will offer up one area that is problematic, and that's the area of what's called public accommodation. So places of public accommodation, such as a movie theater, a restaurant, a supermarket, a hospital, a physician's office, and so on, where you invite public in for services or to buy product, you do have an obligation to make sure that it's accessible to those with disabilities. And so you could find that an individual, take the person over 65, take the person who's got COPD or asthma, who's really worried about getting services at this particular establishment because the employees there aren't wearing face masks, could say to the manager, I need you to ensure they're wearing face masks because I have this disability. And if they refused, that employee, I'm not the employee, that customer may have a viable claim for disability discrimination under the statute regarding places of public accommodation.
Right. Any other questions? I have a question, Bob. So what happens if a company now, they're ready, you know, they've been told, okay, it's time to go back to work, and they can't afford to bring everybody back, but they're bringing 3/4 of their workforce back. But when the employees go back, their jobs are changed. The roles are a little bit different because now the employer has them doing a bit of 2 or 3 other people's jobs. Can they refuse to do that, or how does that work? I have a feeling that might happen.
Laura, I'm going to repeat your question because it was coming in a little broken, but
Okay.
I think what you said is you furloughed a bunch of employees, you're bringing some back, you're not bringing them all back, you're bringing back 3/4 of them, and because you're not bringing them all back, you're going to look for some to pick up the slack and
Right.
and do job duties they weren't previously doing because you're not bringing everyone back.
Right.
You know, and how does that work? So in there's 2 scenarios. One is a unionized environment, which I know you're not talking about necessarily. In a unionized environment, there are restrictions on what you can require an employee to do outside of their job description, outside of their particular classification. It would require collective bargaining. So you'd have to be very careful in trying to add duties to someone who you bring back in a unionized environment. In a non-unionized environment, the employees typically are at will, meaning they can resign or they can be fired at any time with or without cause for any reason, with or without notice, as long as it's not a discriminatory or illegal reason. And so, and you have the ability as an employer in that setting to change job descriptions, to change job duties, as long as you're not giving them duties that are illegal, right? You can certainly, when someone comes back, say, I'm now going to need you to perform the duties of the receptionist in addition to your duties as my admin assistant or what have you, right? I'm going to need you to do additional filing. I'm going to need you to do whatever the case may be. As long as you're paying them for all the hours worked, you're able to do that. Employee complains about it, they complain at their peril, right? So, okay, fine. You're back out on furlough, or I'm laying you off and I'm bringing back someone who is willing to work. Anything you'd add to that, Brian?
Yeah, just one piece, and this is with respect to the Fair Labor Standards Act. So if you're asking, in order for an employee to be exempt from the overtime requirements, their primary duty has to be the performance of functions that are associated with one of the 3 primary exemptions: professional, administrative, or executive. If you're asking an exempt employee to perform, for example, administrative support functions, in order to for that individual to maintain his or her exemption from overtime, just make sure that the primary duty of the individual's employment still remains performance of the exempt functions, and primary duty is typically under the guidance means 50% or more of their job functions involve performance of exempt functions, and whether that's director of HR for the administrative function, whether it's managing 2 or more full-time employees or equivalents for and running the business as the executive function, and whatnot. So just another consideration.
Last thing I'd add that you'd want to, I didn't state initially, is if you bring back an employee and you start having them do someone else's job functions, recognize that that person whose job functions they're doing, one's going to feel slighted, and two's going to look around as to whether or not they have a claim of discrimination, right? So assume that it's Brian and I, and Brian fortunately is, I think, just turned 30. I'm well beyond that age. So you bring Brian back and Brian starts doing some of my job, I could say, well, you should have brought me back. I could have done Brian's job effectively, plus mine. Instead, you brought him back and you did it because I'm over age 40. Now I have an age claim, right? Doesn't mean I win the age claim, but it's certainly something I could think about. And the same would apply male versus female, Caucasian versus African-American, and so on, right? Any protected class, you have to be concerned that you may open the door, at least to the suit. Even if you win it, you're paying legal fees to win it.
Yeah. And so my last question is, or comment is, documentation. You should really keep everything in. If you're rehiring everybody, do you send it out in an email, or do you send it out in a letter? What do you need to keep in documentation, just in case there's any issues with any of your employees?
So
should keep everything in. We should have everything in writing.
Yeah, I mean, it's a there's not a blanket answer to that, other than in general, having things in writing allows you to go back and show that you in fact did something in the event of a lawsuit, right? So that's in general a good approach. Now, having said that, there are times where managers and so on put things in writing that I prefer they not put in writing. They go too far in what they say in their correspondence. So it doesn't have to be particularly formal. It can be an email. If I was calling someone back from furlough, I would do it in writing. Email is fine, letter is fine, whatever you prefer, whatever works for you. And the reason I say I would definitely do it in writing is because if you have that individual who's going to refuse to come back to work out of fear, for instance, or they just feel like they're going to make up a reason, but they're really enjoying being off and getting unemployment compensation and the enhanced benefits under unemployment, in order to contest that, to show that you offered them their job back at the same salary, same hours, or same rate of pay, same hours, gave them a date to return, and that they didn't, you do need that in writing. That's actually a requirement to be able to produce to the DUA. So in that case, I would definitely do that in writing.
That's what I was thinking. Just hold on to everything. All right. I don't know if there's any other questions out there. No? All right. So Bob and Brian, thank you so much. That was very enlightening. I have to tell you, it was interesting. We're all looking forward to getting back to the office, I'll tell you, because I'm sick and tired of being home. And I hope everybody's okay that we recorded this, because I would like to send it to Brian and Bob if they want to share it with anybody, because I think there was some really, really good information there. I hope that's okay with everybody. We'd like to put it on our website in case anybody wants to see it later. If there's an issue with that, you can always email me. Okay? So thank you again. That was very interesting.
Take care.
And thanks everybody for coming on. Thank you guys.
Sure.
Have a great day, everybody. Bye.
Bye-bye.